and all the written submissions filed by Mr. Mahesh Jetmalani and Mr. Shinde, my lords, categorically say there is a split. I have pointed that out, my lords, in paragraph 17, to come here, my lords, and say that we are a faction, we represent the political party, is only sugarcoating, my lord, the factum of a split. Yes, my lords, I had made submissions, my lord, only on writ petition 479, which is challenging the validity of the decision of the Speaker on 3rd of July 2022. That is, my lord, the change of recognition from Sunil Prabhu to Bharat Gogavle late in the evening of 3rd July. Now, my lords, the validity of this decision is, my lords, unconnected with the ultimate, my lords, view which your lordships will take in the disqualification proceedings, whether your lordships want to decide it here or send it back. This, my lords, challenge is an independent challenge. Your lordships will have to determine whether the speaker was right or wrong. And the only defense which was taken originally in the reply was that it is 212. It is inside the house. And I had said that it is completely in the realm of unconstitutionality. There has been absolutely no rebuttal, my lord. That I have indicated in paragraph number 2, my lords, item 2. 3, my lords, I had submitted sub-Roman small 3, that the term political party is not an indeterminate, nebulous concept. Today, there are 30 people claiming, there may be more factions claiming that I am the political party. But on 21st of June, there was only one political party that was, my lord, in writing, which was communicated to the Election Commission, that was headed by us. Not with respect. This is not, my lord, a Narova Kunjarova. My lordships are aware of Mahabharat, my lord, that Ashwatthamo Hata, Narova Kunjarova. Whether they are Shivsena, we are Shivsena. In June, my lord, still they filed a petition on 19th of July. There was no dispute, there can't be any dispute in law that I represented the political party. So that's the second point which has not been answered as far as section 29A is concerned, my lord. Now, my lords, Mr. Sibbal has pointed out about the validity of the whip, my lord, and that only the political party can issue a whip, and that Erskine and May, all that was cited. And my learned friends have argued that no, it's the legislature party can issue the whip, Rule 3.1, etc. The lordships have seen Rule 3.1. Rule 3.1 does not deal with a whip. Neither the form deals with a whip. That is by convention, and in fact affirmed by your lordship's judgment in Mayavati. Kindly have the highlighted portion, my lord. Paragraph 73 of Mayavati, reproduced in paragraph 3 here. Whatever direction is issued by the leader of such legislature party must be regarded as a direction issued by the political party. This was the argument. There is no merit in this contention when the provision in the Constitution has taken care to make a distinction between the legislature party and the original political party and prescribe that the direction issued should be one issued by the political party or by any person or authority authorized in this behalf. There is no meaning in saying that whatever the leader of the legislature party directs must be regarded as that of the original political party. This is Mr. Kaul's argument, my lord, specifically rejected. Now, my lord, all this parliamentary convention which we have set out in paragraph 4, my lord, has not been rebutted. Not even one precedent shown, my lord. Now, my lords, kindly turn to Roman 3. And this is a legal submission, my lord, that having a legislative majority ipso facto or ipso jure is not suggestive of a majority in the political party. My lords, Roman 1 and 2 have already been dealt with. Now, my lords, kindly have Roman 3. In fact, my lord, there are one-member legislature parties. And in those, my lord, circumstances and facts, Election Commission has said that we have to see the organizational majority to see who's the political party. So therefore, my lords, merely saying that you are a legislative majority and therefore you represent the political party is legally incorrect. Now, my lords, reference was made to Sadiq Ali, that Sadiq Ali, my lords, affirms this proposition. In fact, in Sadiq Ali, my lord, this point was kept open, and I have highlighted that, my lord. kindly have a look at Roman 4, the highlighted portion. The present is not a case where a conflict in the has arisen because of one group having majority in the organizational wing and the other having a majority in the legislative wing. This has fallen for consideration here. Now, my lords, one submission was made by Mr. Jetmalani yesterday that look here, we are also members of the Pratinidhi Sabha. Therefore, we represent the political party. Lots on affidavits in the election commission and also here, for which there is no rebuttal. Out of 220 Pratinidhi Sabha members, 160 plus, my lord, have supported me. 160 plus, not rebutted. Now, my lords, kindly see the next submission which is made. And this is again Mr. Jetmalani's submission, that Quixote said in paragraph 97 that the decision of the speaker is not covered by 212 and that the rules made under paragraph 8 have a constitutional status and therefore violation of that 2-day period or 7-day period is violation of the constitutional mandate. Totally against Ravi Nayak, my lord. Not even one judgment was cited in support of that submission, but kindly see Ravi Nayak, it's covered. Now kindly see paragraph 8, my lord, the highlighted portion. The disqualification rules are procedural in nature and any violation of the same would amount to an irregularity in procedure which is immune from judicial scrutiny. Then, my lords, I just have 30 seconds, my lord, I'll just finish, my lord. My lords, then a reference was made to some speeches, my lord, that I have dealt with. Lord, some speech of some DG is totally inadmissible. My lordships have held it time and again, which your lordships have seen in Kalpana Mehta Constitution Bench and also in Shivraj. Speeches by, my lords, members, totally irrelevant, my lord, to decide what the scope of the provision is. Yes, my lord. Then, my lord, para 6, they said that mere non-attendance of a meeting will not amount to a para 21A. Specifically, my lord, this was the issue in Srimant Balasaheb Patil. One meeting they didn't attend. It was held to be a para 21A, which I have reproduced, my lords, in paragraph 14. Now, the last thing is important. Kindly have paragraph 15. My lords, time and again, my learned friends, my lord, said that we have never claimed a split. In fact, I remember, my lord, Honorable Justice Kohli asking Mr. Kaul, is it your case that there is a split? And he said, on more than, my lords, 5 occasions, which I have reproduced, kindly see this. First, our case is not a split at all. I have never argued I have a split. Now, kindly see the submissions before the Election Commission. And now the cat is out of the bag. Please have a look at paragraph 16, my lord, of my note. And I've reproduced paragraph 7 of their petition before the Election Commission. In view of the above mentioned facts and circumstances, it is evident that there is a split in the Shivsena. And all the written submissions filed by Mr. Mahesh Jetmalani and Mr. Shinde, my lords, categorically say there is a split. I have pointed that out, my lords, in paragraph 17. To come here, my lords, and say that we are a faction, we represent the political party, is only sugarcoating, my lord, the factum of a split. Lords, lastly, my lord, ultimately your lordships will decide. Lords, I am reminded of a, my lords, Sanskrit Subhashit, my lord. And it says, my lord, Kakaha Krishnaha, Pikaha Krishnaha. That, my lord, the crow is also black, the cuckoo is also black. Ko Bedaha Pika Kakoe. What is the difference? Who's the Shivsena here? Vasanta Samaye Prapte, Kakaha Kakaha, Pikaha Pikaha. And I'm sure, my lords, the time of judgment will be clear, my lord, who's the real Shivsena. Thank you so much.